So with that, I want to move to our first segment, in which we're going to explore how these causes, including the pandemic, mental health crisis, and all the things that we talked about, how they've impacted how we work. And for this segment, I'm going to ask Seth Holland, Ioana Pantis, and Pressey to walk us through what should be on our radars with respect to the how. Over to you guys.
Thanks very much, Laura, and good morning, everyone. COVID, of course, has introduced a new scope of considerations for employers, impacting how employees work. So that's whether you're returning employees to the physical workplace or considering long-term remote work arrangements. Put simply, the expectations on employers and employees are now significantly different than they were prior to the pandemic. Failure to meet expectations and legal standards from an employer perspective could result in fines and offenses under applicable legislation, but also serious harm to reputation and business interests. At the same time, pandemic fatigue has hit Canadians hard and has had a substantial impact on employee mental health. It has also resulted in feelings of frustration and impatience with COVID health and safety measures. A recent study from ADP Canada revealed that nearly half of Canadian workers feel less engaged with their work since the onset of the pandemic. So given these trends, there's a number of key considerations that employers must be aware of. I'll start with health and safety in the workplace, a big one. Canada is starting to see momentum, of course, as we all know, in terms of vaccine rollout. That's nationwide. However, employers cannot lax in terms of their compliance with COVID-related standards and precautions just because vaccines are more commonplace. Failure to abide by COVID-specific regulation and guidelines that we have all become accustomed to in the workplace can still result in offenses and penalties under COVID and health and safety legislation. Employers in every province across the country have a general duty to take all reasonable precautions to ensure the health and safety of their workers. This still includes compliance with applicable provincial and local COVID guidelines and regulations. This is something employers need to adhere to on their end. However, the obligations go both ways, and employees can be subject to discipline and even dismissal in extreme cases for failure to comply with employer-mandated COVID policies. Off-duty conduct is the next topic I want to talk about. So at this time, employers are more likely than ever to come across employee off-duty misconduct, given the rise of frustration I mentioned related to COVID protocols and the rise in rallies and large gatherings related to anti-vaccination and government COVID measures. You may have seen recent stories in the news about how social events that violate COVID regulations can quickly go viral and be quite damaging to a company's reputation. In our own dealings, through our own work, we've seen several instances where employees have posted on their social media social events in which they're clearly in breach of applicable COVID-19 related restrictions. These scenarios should be dealt with accordingly. Where off-duty conduct results in real and legitimate potential harm to an employer's reputation or creates a scenario where an employee's misconduct impacts their ability to perform their job or operate in the workplace, in that case, off-duty conduct can give rise to a basis for discipline or even just cause for dismissal, again, in extreme cases. However, with that being said, with respect to COVID-related misconduct or any other off-duty misconduct, or just cause scenarios at large, misconduct should be evaluated on a case-by-case basis. As an employer, you can't make a reactionary decision to terminate an employee for cause, or you could face significant liability by way of wrongful dismissal and related damages. So now I'd like to jump to another hot topic in employment law. That's vaccinations. So vaccinations, of course, I'm sure I don't have to tell everyone, is a hot topic right now in employment law and just at large, as employers are wondering whether mandatory vaccinations can be implemented in their workplace. The law on COVID vaccinations is largely uncharted territory, as Laura sort of alluded to before. There are a number of considerations that should be made, though, prior to implementing vaccination requirements in your workplace. The first, the big one, the big risk you want to avoid in this scenario is constructive dismissal. So it remains to be seen whether a mandatory vaccination policy could provide an employee with a basis to claim that they've been constructively dismissed. So to take a step back here, a constructive dismissal occurs when an employer makes a fundamental term or a fundamental change to a fundamental term or condition of the employee's employment. Essentially, an employee is entitled at that point to treat the change as if their employment has become terminated, and it gives rise to their dismissal entitlements. So if an employer doesn't have an effective termination clause in place, that means an employee could be entitled to common law reasonable notice, which can range anywhere from a month up to 2 years in termination entitlements that an employer has to pay out upon the constructive dismissal. So the issue here and how constructive dismissal relates to vaccination policies is that presumably when the employer and the employee first entered into the relationship, they didn't contemplate COVID-19. They didn't contemplate vaccinations at all. So now an employer implementing a mandatory requirement that an employee get vaccinated in the middle of their employment relationship gives an objecting employee the basis to allege that the fundamental terms and conditions of their employment have been changed, and therefore they've been constructively dismissed. So this is really one of, if not the big issue with respect to mandatory vaccination requirements. An important thing to note about vaccination requirements, though, is the risks from a constructive dismissal perspective are inherently different when it comes to new versus existing employees. Existing employees, when you implement the mandatory vaccination requirement, there's going to be the constructive dismissal risk, unless you get a contractual sign-off by employees and meet certain legal entitlements associated with that. However, if you're introducing a vaccination requirement for a new employee, employees who sign off on mandatory vaccination as a requirement of their employment for a new employment agreement will not be able to claim constructive dismissal against their new employer. However, it should be noted more high level that human rights obligations continue to apply regardless of whether it's a new or existing employee that is being subject to that vaccination requirement. Now, the last point I'd like to touch on when it comes to vaccinations before moving on is reasonableness. Now, reasonableness is a broad term, but it's very important when it comes to vaccinations. And it's a factor that's going to be relevant when a court or adjudicator assesses whether an employer's vaccination policy is enforceable. So there's no case law at this time considering the reasonableness of a COVID vaccine, given where we are in the process. However, existing case law from previous years based on flu vaccines that have been introduced in the workplace tells us that in the context of COVID, it's very likely that to justify a mandatory vaccination policy, absent a contractual right to do so, an employer would have to demonstrate that the vaccine is reasonably necessary as a health and safety measure in its workplace, given all the factors that are relevant. So a court or adjudicator would look at the threat of the risk in the employer's particular workplace, the particular line of work that the employer is in, and whether that creates some sort of enhanced risk of spread or the impact if someone were to get COVID-19. And importantly, whether personal protective equipment, think gloves, think masks, etc., or other measures, think social distancing measures, could achieve those same health and safety risks or health and safety measures that the employer is intending to achieve by implementing the mandatory vaccinations. So if another measure could just as well ensure the safety of your workplace, it's less likely that a mandatory vaccination policy is going to be enforceable from a legal perspective. So while it remains to be seen how courts will consider vaccination policies, both in the unionized and non-union context, an employer who can demonstrate based on those factors that mandatory vaccinations are a reasonably necessary measure to ensure the health and safety in their workplace are more likely to have their vaccination policies upheld at law. And from now, I will hand it over to Ioana to cover additional considerations in our How We Work segment. Over to you, Ioana.
Thank you, Seth, for laying the groundwork of how the way we work has changed during the pandemic. As you were alluding to, it's no secret that accommodation has become a hot topic during the pandemic, and employers have been finding it more challenging than ever. From accommodation for mental health disabilities to family status, we've seen the need arise across a range of industries and businesses. Employee accommodation needs and requests are unlikely to decrease anytime soon, and we've certainly seen in our practice that they're not decreasing. Across the board, employers have been quick to pivot and meet their legal obligations to employees, while trying to balance those against their operational needs to keep business moving along as normal as possible. In large measure, we've seen employers really step up to the plate with this. When receiving accommodation requests, many employers often know that each accommodation request has to be assessed in the context of an employee's needs and limitations, including how those needs may change over time, as well as the employer's workplace. Now let's talk about 4 main types of accommodation and other requests employers are likely to face and the key legal considerations involved for each. First, mental health. It's a huge one. Both from a good business perspective and to meet broader health and safety obligations, employers need to ensure they are taking steps to avoid employees getting burned out. For employees who have already experienced negative mental health conditions, employers also need to consider that they have a twin duty under human rights legislation. So first, it's the duty to accommodate mental disabilities, much in the same way as employers would accommodate physical disabilities to the point of undue hardship. But second, it's also the duty to inquire about mental health disabilities. This is a positive duty to seek information about limitations an employee may be experiencing without the employee expressly asking for accommodation, but behaving in ways that suggest they do need accommodation. For example, employers and people managers should be on the lookout for greater conflict with coworkers, increased absenteeism, chronic lateness, or a sudden drop in performance. In our own practice, we've actually seen a serious situation where an employee started becoming uncharacteristically very argumentative with coworkers, and it started affecting their work too. The employer was considering disciplining the employee, but we cautioned the employer that the employee's mental health may be in decline, and so human rights implications may arise. So they made inquiries with medical letters and received assurance from the treating physician that the employee was receiving treatment and would get better soon. The employer averted discrimination risks by not disciplining the employee for behavior that arose out of the employee's disability. Employers also need to normalize talk about mental health in the workplace. This has benefits for everyone. It helps employees come forward to begin with, and it also helps employers more readily approach an employee they are concerned about without it being unnecessarily uncomfortable or perceived as out of the blue. We've actually seen several of our clients proactively provide additional resources to employees throughout the pandemic, and that's been really well received by employees. Practically, and from a legal point of view, employers need to ensure they are documenting the accommodation request to the employee in a sensitive way, while also asking specific questions to help them meet their operational needs. The proven formula we use in helping our clients is first engaging the employee with a letter to help them explain understand why the employer is seeking medical information. And we communicate to them that the employer intends to help them succeed in their role and provide reasonable accommodations. The letter to the employee then encloses a letter to the treating physician, asking things such as if the employee has any limitations arising out of a disability that may affect their work, whether an employee is receiving treatment to improve their medical condition, and the prognosis for recovery to full duties. When employers receive the response from the treating physician, they then have to engage further in the process and determine what reasonable and not perfect accommodations they can provide to the employee. This may look like a different start time, increased breaks, or greater access to supports such as doctor's appointments throughout the workday. Now moving on to family status accommodation. We know certain statistics support that family status needs are on the rise. For example, insights from StatCan in December point to the unequal impact of the pandemic when it comes to childcare on women and men working from home. Homeschooling predominantly fell on women, with 64% of women as opposed to 19% of men being primarily responsible for homeschooling, which may also result in mental health consequences for women. Another StatCan survey pointed to 74% of individuals feeling very or extremely concerned with balancing childcare, schooling, and work. What these numbers say for employers is that they need to continue being flexible and reasonable with employees. But what we've also seen with some organizations is how they need to continue to ensure they are treating all family status accommodation requests in the same way for everyone and documenting those requests as they would requests related to disabilities. The risks of not documenting the process consistently are: one, practically, the employer may be overstretching themselves if caregiving needs change over time and other caregivers can share in the responsibility. And two, if an employee has received an informal form of accommodation for a long time, but suddenly has that taken away, they may feel targeted and also have the basis for a discrimination or possibly a constructive dismissal claim. Moving on to work location. With the increasing need for employees to work from home and take care of children, there are also employees who don't have caregiving obligations wishing to remain at home in the long term, or who may be eager alternatively to return to the office. Employers may receive these requests informally from an employee or formally from the employee's doctor. Employers should ensure they understand the basis of an employee's request either to work from home for a long period of time or to return to the office. And if it's a preference or if there may be a hidden mental health or caregiving need for it, then they should treat the request in the same way as they would any other medical request and document it to obtain further information from a treating professional. In some cases, the request may not be granted under human rights legislation, but the employer will first need to eliminate that possibility by documenting the process. Moreover, before an employer requires an employee to return to the office, they should consider constructive dismissal exposures of a sudden change back to brick and mortar. Before the lockdown, we had inquiries for employers wanting to return employees back to the office full-time, and we advised them to communicate expectations ahead of time and gradually ease employees back into the office. This minimized constructive dismissal risks. And finally, vaccines. This is a newer issue we've just started seeing arise in various workplaces. We've had several clients approach us that operate in environments with vulnerable populations or where virus spread is more likely to happen, that have been strongly encouraging employee vaccinations, but have received pushback from some employees, which is sometimes grounded in generalized suspicion or fear of negative consequences. To navigate this pushback, employers will need to determine if encouraging vaccines is a legitimate need for their workplace. Then understand why an employee may be refusing a vaccine, and then determine if there is any disability or other protected ground that may arise, such as creed or religion. When it comes to an employee's refusal to be vaccinated on the basis of religion, there are a small number of religions that may support this view, but it's actually more likely employers will encounter vaccine refusals on the basis of creed. Creed is a broad term to encompass a range of beliefs and practices, including those not tied to any religious institutions. We've had recent guidance from the Human Rights Tribunal of Ontario related to a mask refusal on the basis of creed, where creed was defined as a recognizable, cohesive belief system or structure. In this decision, the Human Rights Tribunal held that the refusal to wear a mask was a mere political opinion and did not rise to the level of creed. So this to say that it's possible we may see the same outcome for an employee refusing a vaccine claiming it's due to creed. But until then, employers will still need to engage in the process of asking why an employee is refusing a vaccine and determine if there is a legitimate health and safety need for everyone to be vaccinated in a workplace with risks that cannot otherwise be reasonably reduced with other means, such as daily testing or continued use of PPE, as Seth was mentioning. So overall, from a human rights related request to those not based in human rights, employers will need to take requests in good faith and determine what their obligations may be before denying a request. Over to you, Alex.
Thanks, Ioana, and thanks, Seth, for setting out the many considerations that employers are having to juggle that we've seen so far in the pandemic. So with respect to things to take away from this segment, there are a couple of things we've identified based on our practice and the advice that we've been regularly giving to employers having to navigate really the minefield of all of these different considerations. The first is really to make sure that as best you can, you're keeping up to date on developments. As Seth mentioned, there have been so many developments, public health developments, things are changing, vaccinations happened, vaccinations altered also how we do work. The reality really is constantly changing with respect to what we've discussed in this segment and the broader landscape that Laura touched on at the beginning of our seminar today. What employers are really going to want to make sure that they do is ensure that everything that's still relevant to your workplace is still being followed. So even though new things are happening, the things that have been haven't necessarily gone. They're not necessarily old news. So for things like health and safety requirements that you may have put into place with respect to physical distancing, or having some employees work from an alternate location, work remotely, personal protective equipment or sanitization requirements in the workplace. Even though things, new things, exciting things are happening, like vaccinations being more broadly available, these previous things are still going to be relevant. And the public health requirements, as the government and public health agencies have said, are still in effect. So employers are going to want to make sure that you're staying the course but that you're also staying flexible because new things are going to happen. Things have been and are going to continue over the next few months to be changing. So again, keeping up to date on all the developments and making sure you're working in any new things into your plan is going to be very important in making sure that you manage any potential risks. The other takeaway we want to bring to your attention is the importance of monitoring off-duty conduct. And, given everything that's been going on, as Seth said, you really don't want to be the last one to know about some of these things. An example that we can give you that I'm sure many of you have heard about, have read about, probably have heard jokes about for many weeks and months following it, was the example that was in the news with respect to Mattamy Homes, where there were some construction workers who decided to throw a party. There was alcohol involved, there were other things involved, and it became the talk of the town, the region, the province, if not further. And so in that case, the situation was all over the media, it was all over social media, and that sort of thing impacts the employer's reputation. It can impact workplace morale. It can impact the employer's credibility in terms of the measures that are being put into place to keep other employees who wouldn't be comfortable with this behavior healthy and safe. And so with respect to monitoring off-duty conduct, we're not by any means suggesting that you're micromanaging every single thing that employees are doing in their off time, but just generally, employers may want to consider strategies like even setting up an alert for certain things in the news, just keeping apprised of things, contacting key employees who may be trusted and who may know if other employees are going to be participating in things that could negatively impact the employer's reputation. Because again, in our new globalized and frankly increasingly virtual society, it's very easy for employees to be tied to employers in ways that weren't as easily accessible to everyone on social media and in the media before. You also want to make sure with the many accommodation requests that employers have been facing and the different varieties of accommodation requests that I want to walk us through, that you are really taking all accommodation requests in good faith. And really the process for accommodation requests of various varieties is going to be quite similar. And we do have an article in our newest newsletter that I'll point you to called 8 Steps to Reasonable Accommodation that gives you a bit of a checklist that you can follow. But in terms of the actual process, as Ioana said, you want to make sure that you are accepting all accommodation requests and not making any prejudgments or assuming that an employee doesn't need the accommodation or is not being entirely truthful with you. Sometimes those things do happen. We've certainly seen employees in our practice misuse the accommodation process. But unless there's a clear and objective reason why an accommodation request isn't entirely honest, forthcoming, truthful, and sometimes even when there is, employers are going to want to make sure that you're taking it in good faith, you're getting all the information you need, and if at the end of that process, the accommodation need isn't substantiated, that's fine, but you've made sure that you've documented everything and can actually support that position should the employee dispute it, should they bring a claim or anything like that. And so to make sure that you're doing this, you want to document the accommodation process. I won't walk through the documentation in detail because I know Ioana's already set it out in the considerations, but just as you are asking for letters, as you're asking for proof, make sure that these things happen in writing and make sure that these are kept. Because again, if the accommodation request is disputed, if the employee says, well, my employer didn't listen to me, they discriminated against me, this is something that you're going to be very easily able to point to say, look, we sent you letters, we explained the accommodation process, we explained our role, we explained what we expect from you, employee, because it's very key to remind employees that they also have a role to play in the accommodation process. You as the employer have to accommodate any accommodation requirements under the Human Rights Code, but the employee has to give you the tools required to do so, which is going to include things like medical information, specifically prognosis, not diagnosis information, and information about any medical limitations they may have in the context of an accommodation with respect to a disability. Additionally, in the kind of circumstance that we're in now with the pandemic, and particularly with the echo pandemic that we've already seen take hold with respect to mental health, it's increasingly important for employers managing accommodation requests to be able to strategically raise conversations regarding mental health in the workplace. A key factor to being able to do this is laying the groundwork and making sure that you are providing resources, but widely that you're cultivating a stigma-free workplace. And the way to do that, in addition to providing resources, is through policies and through specific training that I'm going to touch on in just a moment. But the reason this is so important is that in a recent survey done by Stats Canada, we've seen that 40% of Canadians surveyed today still believe that their career is going to be very negatively impacted, that their future career prospects will suffer if they disclose a mental health issue to their employer. And what you don't know about, you can't react to. And if the employee is able to say, well, the employer should have known, because the employer does have a duty to inquire, where you see some of the things that Ioana was talking about in your employees, the changes in behavior, the things that could lead to a mental health concern. You want to make sure that you are handling those to mitigate your risks. And so really the key thing here is to make sure that you have specific training for your people leaders, your frontline managers who are going to be having these conversations. You want to make sure that they know what to look out for. You want to make sure that they can handle it in a sensitive manner. And you also want to make sure that they're aware of the legal framework. Again, if there is a potential concern, if you're seeing something that you need to address, you can ask the employee for their prognosis. You can ask for medical limitations. You can't ask for diagnosis. You can't ask, what is the condition, because that's not something that the employer is entitled to know in the accommodation process. Other than that specific thing, what employers should really keep in mind, and this goes with cultivating the stigma-free workplace, is that in many ways, the overall general process for dealing with a mental health related disability is going to be the same as dealing with any other disability. You're going to want to ask for information, you're going to want to take the request in good faith, you're going to want to document the process, and you're going to want to make sure that you can put in a reasonable accommodation. Not a perfect accommodation, not exactly the thing that the employee wants, but something that's reasonable and addresses all the limitations at play. Related to this, as I had mentioned, is you're going to want to make sure that you're drafting and revising relevant policies. And this is really a key takeaway that I think you'll hear a couple of times from us today, because policies are really your groundwork. They're how you set expectations and tell employees what the rules of the game are when the employment relationship comes into play. And in terms of drafting policies with respect to how we work and how that's changed, there are quite a few key policies that employers are going to want to look at. Going to want to look at vaccination policies and make sure that your vaccination policies address things like, is vaccination going to be mandatory in your workplace? If not, are you going to encourage it? Will you incentivize it? Even if it's not an appropriate locale for mandatory vaccination due to many of the considerations that Seth flagged for us, perhaps you may want to tell employees, look, we think the vaccine is safe. We think it's a great measure. If you want to go get vaccinated, we'll give you some time off to do that. Or if you did already get vaccinated, we'll give you an amount equivalent to the paid time off we would have given you. And in exchange, just tell us that, show us proof that you've gotten the vaccine. This is a way that employers can still incentivize vaccination, make sure that employees are getting vaccinated, make sure that the employer knows, but without mandating it, which is something that in a lot of workplaces, an employer just may not be able to do given the current circumstances and the current state of the law. Other policies you may want to look at are things like your off-duty conduct policy. Again, just because of the prevalence of the related issues, your off-duty conduct policy may benefit from having some examples of the kinds of conduct that, could really tarnish the employer's reputation and that employees should still steer clear of. Now, your policy isn't going to be able to cover every single example, but you are going to want to make sure that you touch on the key different categories so that it's easy to extrapolate. And again, the expectations are set and everybody knows what's expected of them in the relationship. With respect to the accommodation policy, you're going to want to, even though it's not legally required, have a policy so that you can point to it and so that employees know that they can come forward, but also so that you can make it very clear in the policy that employees also do have that obligation to participate in the process. The employer can't do it alone. And health and safety, which is what accommodation is related to in addition to human rights, the obligation to make sure that employees can work safely and that you're taking care of their health and they're taking care of their own health and that of others in the workplace, that's a joint venture. It requires both parties to be acting in concert, and putting it right in the policy helps make it very clear to employees what you're going to need from them. Similarly, again, health and safety policies, you're going to want to update to make sure that they're touching on all of the relevant public health restrictions, that you're updating it to make sure that as your return to work plan is going through its processes, your policies are still relevant and capturing everything. And there may be other policies that you may want to look through. So given the changing sort of landscape that we're in, now is really a good time for employers to just take a fresh look, see if there are any policies that may be a little bit outdated, that may not reflect how you're actually doing business, and bring those up to your current standard and your current needs. And finally, when you've done all that work to make sure that you're drafting and revising these policies, you want to make sure that you're clearly communicating the expectations. And so what we've seen in our practice, unfortunately, very often is employers who have great policies. They're perfect. They cover all of the legal requirements. They cover the best practices with respect to HR considerations, but employees just don't know about them. And it may be that they've been, updated, sent around, they get lost in the emails, or employees look at them, sort of click, I agree, but they haven't read them, they don't really know what's in there. Sending the policies around is in many cases not going to be enough for an employer to make sure that, again, everything is communicated and your policies are doing the work that you want them to do for you, of really setting the expectations and making the terms of the employment relationship clear. So in addition to sending out the policies, a lot of employers would benefit from having some training. And it doesn't need to be, a big elaborate process. It may be something like having a bit of a town hall, walking employees through the policy, giving them a chance to ask questions. And if you do this with key policies, then you make sure that, again, expectations are set, everybody knows what they need to be doing, and that hopefully will make the transition in some of these situations that you're trying to navigate more smooth. The other thing that you really want to make sure in terms of communicating expectations is to have focused training for your leaders on the policies, because your managers, your frontline people leaders are the ones who are going to role model the policies. They role model the behavior. They're going to be answering questions from employees. And it's really important that with respect to some of these policies, they know what the procedures are, they know what's expected of them, and they know that in certain circumstances, there can be personal liability for supervisors and managers who don't do what they're required to do under certain policies. In the current pandemic situation, what we've seen is that soft skills for managers are becoming increasingly important to a lot of employers, particularly with things like dealing with accommodation requests and mental health accommodations. You want to make sure that your managers are empathetic, that they know how to have these tough conversations, that they can recognize the relevant signs of potential mental health accommodation needs, and that they know what the process is to deal with them. And, we had a situation a few months ago in our practice where, again, an organization had a great accommodation policy, had a very centralized, clear system in place, but there was a manager that wasn't entirely aware of this. And as a result, there was an employee who asked to come back to the workplace. And, given the nature of this industry, this request was approved, but then the employee said, well, I've been working 6-hour days, so I want to make sure that I can still keep working 6-hour days when I'm back in the office. And human resources essentially said, what are you talking about? And it turned out that the manager had made a side deal with the employee and sort of approved a one-off accommodation, not in accordance with the process, because they didn't know or weren't aware or weren't upskilled to make sure that they weren't deviating from the established practices. So to make sure that you're not having these sorts of issues, you again want to make sure that your people leaders are really trained as well, with specific focus on what is going to be expected of them. because really the communication is key. And communicating the expectations is how you make sure that employees are going to be aware of them and be able to follow them. So employers who, do keep up to date on developments, monitor for off-duty conduct issues, make sure that they're legitimately considering accommodation requests, review and revise their policies, and then let all of their employees know about what's expected, are going to be really well poised to navigate the changed and changing landscape in how we work as a result of the pandemic. So with that, I will turn it back over to Laura to take us into our next segment.